Hello, everyone, and happy Wednesday. I am Elsa W. Smith, your Maryland estate planning attorney, and I'm the owner of the law offices of Elsa W. Smith, where our mission is to empower women through estate planning. Welcome to another episode of Women Winning Wednesdays. Through our guests and educational content that we provide, my hope is to provide you glimpses of what an empowered woman is and the tools that she needs to win. As a reminder, since we're streaming on StreamYard, please give StreamYard permission for us to view your comments. We want to hear from you and know that you're pacing right along with us. So go to StreamYard.com/Facebook, StreamYard.com/Facebook. Say hi, let me know where you're listening from. And if you catch this on the replay, make sure and put #replay in the comments. Now, let's get rocking and rolling. Today, our topic is what to consider before drafting your will and mistakes to avoid. Now, first of all, let's start with the basics. Now, many of you who follow me on social media and have viewed our video library on YouTube know what a will is. However, for the benefit of those who are, pretty new to estate planning, a will is basically a document that coordinates the distribution of your assets and can name guardians for minor children. Okay, so again, the topic today is what to consider before drafting your will and mistakes to avoid. Before I get into the things that you should consider, I kind of want to back into it by starting off with 6 mistakes you should avoid. So again, if you're taking notes, 6 mistakes that you should avoid. So number 1, choosing the wrong person as your personal representative. Now, a personal representative is the person who's responsible for, settling your estate, paying any remaining debts you owe, and then dispersing your assets to beneficiaries. The personal representative doesn't have to be a financial or legal professional in order to do the job, but they should be someone that you trust, right, to carry out your wishes. If you put this responsibility of settling your estate into the hands of someone who's really not up to the task, they could end up creating, a huge problem for your heirs to sort out. In the worst case scenario, a personal representative can even try to, misappropriate, steal some of the state assets for their own personal gain. So it's really important to choose someone, that really has the right skill set for this very important task. Number 2, excluding stepchildren. Right? Now, if you have stepchildren with a partner, simply stating in your will, referring to them all as my children, may lead to some confusion and will not automatically cover them. This applies even if you raise them from birth. If you want your stepchildren to be included in your will, you are encouraged, highly encouraged, to mention them by name, explicitly mention them. Now, legally, adopted children will usually be considered the same as biological children. Okay, but it's always a good idea. It's kind of standard practice just to name who your children are. And let's see, mistake number 3. Here we go. Leaving out an heir without an explanation. Now, you are free to distribute your estate any way you wish. And this means, you can also disinherit someone if you wish. Now, although you're legally required to provide a reason when you simply leave out like an obvious beneficiary without an explanation, it's going to increase the likelihood of a challenge to the validity of the will. Okay, so it's just a best practice to acknowledge the individual and be clear that your intent is to disinherit him or her. Now, having said that, there is a really big exception as it relates to spouses. In Maryland, a decedent cannot entirely disinherit a surviving spouse, right? This generally happens like when a surviving spouse is left with nothing or very little under the will. If a Maryland decedent dies with a will, a surviving spouse has the right to renounce the will and then elect to take what's called an elective share. Now, talking about the elective share is beyond the scope of this Women Winning Wednesday, but it's important to mention it here, specifically in light of fairly recent developments in the law, making it even more difficult to disinherit a spouse. You are welcome to contact our office for more information on this, but regardless, it's very important to speak with an attorney. Please don't try to DIY this at all. Moving right along. Mistake number 4, forgetting your fur babies. Now, sometimes pets outlive their owners, but if that pet isn't accounted for in your will, it can be difficult for the beneficiaries to know what your intentions are. It's always best to talk with the person that you choose or that you're considering to take care of your pet, while you're alive and well, while you're not rushed, and just ask them if they're willing to take on that responsibility, and then, be on the same page about everything. The second point is to consider whether you want to make any financial provisions or allocations in your will for the care of your pets. Pets can be expensive. I know, I'm a pet owner. And the costs can include things like insurance, pet vet bills, feeding, especially if your pet is on a particular diet. And an alternative to making, an outright, monetary gift to a beneficiary in your will is to create a pet trust. And that is a particular type of trust created for the upkeep of, a specific family member, furry family member. Number 5, ignoring matters that are outside of the will. Now, let me give you an example. If your daughter is named a beneficiary on your bank account, her status as a beneficiary on that account supersedes or trumps whatever you say in the will. This means that while drafting a will, you should also make any adjustments to property that the will may not account for. If you want a significant other to inherit your accounts when you pass, you'd need to go through the process of removing your daughter from those accounts first and adding that significant other. Again, things like bank accounts, life insurance, retirement plans. The beneficiary designation on those forms will trump anything that you indicate on your will. I can't stress that enough. And then number 6 out of the 6 mistakes. There are more, but today we're just covering 6. Assuming your family can manage your estate without a will. Now, if you die without a last will and testament, first of all, it's called dying intestate. Your family is going to need to seek a court order to make many of the important decisions that are going to need to be made. Now, furthermore, your state's intestacy laws, I've mentioned that word earlier, that's going to dictate who inherits from your state. Like I always say, if you do not have a plan, the state will for your assets. So keep that in mind. And it may be contrary to what you would have wanted or what you think is best for your family. Okay. I mean, is this helpful to anyone? Let me know in the comments. I'm sure it is, because I hear these, like, oh, I didn't consider this. So yeah, just let me know. Let me know in the comments. Now, these are just a few of the mistakes you should avoid in before you consider crafting a will. Now, let's discuss what you should consider when drafting your will. And I want you to stay tuned until the end so you can learn how to get a free will preparation checklist that identifies the points that I'm going to cover now, and a few more. So stay tuned. So I want you to ask yourself, I want you to consider, who's going to raise your kids? Who will raise your kids, right? And really give this some thought. Don't assume, like so many people I've spoken to do, that your family will somehow swoop in and they will figure this one out for you. They're your kids, right? And it's unfair, quite frankly, of you not to have a plan in place as to who is going to take care of them. You'll spare your kids and your family members stress by knowing all of this in advance and just documenting it. And by the way, make sure that you talk to the person that you choose to see if they're ready, willing, and able to take on that huge responsibility. Of course, if the worst happens, right? Another question: who will be your backup in case your personal representative cannot serve? And I'm referring to it as a backup, but technically it's called the successor representative, right? If you are named a personal representative of an estate, you have to think carefully about your willingness to fulfill this important responsibility after a death. Many people, right, who are named by the deceased as a personal representative, they decide that they'll go ahead and do the role because they want to honor the wishes of that departed loved one. However, it is not always practical or possible for a person who's been named personal representative to actually serve as the personal representative. And if you listen to a prior episode of Women Winning Wednesday, I talk about the enormous responsibilities involved with being a personal rep. And in cases like this, you need to know that ahead of time. If you do not want to be a personal representative, you don't have to, right? What will happen is that the court, through the probate process, will simply choose someone else and appoint someone else to fulfill that role. Okay. Another question along the same lines: who will be your backup, again, successor, if your guardian cannot serve? Now, here we're talking about the guardians of minor children. It is always a good idea to have a successor in place in case, as I said previously, the person is unwilling or unable to serve. The truth is that life happens. The person can become ill. The person can be part of a job that relocates them, to another part of the country. And, it's just not practical for them to take on that responsibility. So it's really, really important just to have that open line of communication. The other thing, when we're talking about someone that's going to raise your children, is about, morals and values. I mean, are they really aligned with yours? If you subscribe to a particular religious beliefs, is this person that you're considering, are they going to honor that when you're no longer here? Are they the type of person that you want your children to emulate? Those are pretty heavy things to consider. And and you have to consider more about, they're just a nice person. Well, no, I mean, do your kids have a good relationship? Do they like that person at all? Does that person, do they have a job? Let's be real. Do they have a job? Are they, responsible? Those are the characteristics that you want to look for in naming a guardian and a successor guardian. Okay, really important things and decisions that are best best made after careful thought. And a lot of times when my clients get to this point in the process after they've after they hired us and we're going through everything, they actually have to take a pause, and the spouses have to have a meeting and say, honey, well, who do you think, and so forth, and there's that family discussion, because it's that important, right? So please do not just take that decision lightly. Another question is, do you want to give money to a cause or organization that is important to you? This is one that a lot of people just don't consider. Or I should say, they consider giving gifts to, family members, and we'll get to that in a minute. But they forget a lot of organizations that have meant something to them, colleges, giving to a scholarship fund, sororities and fraternities, donating to them if they played an important role in your life. And when we're talking about sororities and fraternities, a lot of times the answer is yes. Then giving a charitable donation or making some sort of gift or funding a scholarship is a way of saying, your legacy, right? That is an example of you making an impact in the lives, when we're talking about scholarships, of the next generation, right? Or when we're talking about different charities, if you're an animal lover and want to make a donation to, a local animal shelter, or say if you are recovering, saying from, a particular disease, a life-threatening disease, and you want to make a donation to, say, the Cancer Association or lupus or, Alzheimer's, what have you, you can indicate that in your will. And that's all a part of your lasting legacy. Next thing to consider is, do you want to leave specific gifts to people? Now, here I want to share a story. I have a former client who shared with me a very creative and fun way that she found to leave gifts to her 3 adult children. So she hosted kind of like a family gathering, and she gave her 3 adult children Post-it notes in different colors. And she said, you are to go through the house and tag items that you would want to keep, right? I thought it was fun and creative. And if there, by some chance, two of the siblings wanted the same item, they had to negotiate amongst themselves, or, figure something out before the end of the gathering. And that, I thought, was really creative, really fun way to kind of, indicate like who's going to get what. And it just spares all that bickering and that nonsense that happens after someone passes away. And it contributes to that family harmony. So I wanted to share that with you, my audience, because I thought that was a really neat and creative way of leaving gifts to specific people. And now, another thing I wanted to share, I had another client who had an extensive musical collection, and she had different albums. And yes, I'm talking albums. I'm dating myself, but yes, classical, not genre classical, but classics in the sense that they're, they stand the test of time. And her collection was pretty extensive. Now, in her case, she knew that she wanted to leave a certain albums to certain people. So for her, and it was quite extensive. So for her, we actually had to create a spreadsheet. It was that detailed, with the artist and the album and so forth, and who was to receive it. I actually enjoyed that process. It was, I love my clients because they're so eclectic in their interests, and I learned something from each one. But creating that list and having that organized when we presented it to her gave her such peace of mind. She realized exactly how large her collection was, and she had that peace of mind knowing that people weren't going to be bickering about who gets, a Coltrane album versus, some other album, whatever. But the point is, it's being organized, having that forethought and the planning. And that's the kind of service that, at least in our firm, that we provide to our clients. Some clients, don't need that level of planning, but if they do, that is something that we're able to offer. The next thing is to consider is what's going to happen to your digital assets. Those are like pictures, music, other items stored in the cloud or on social media. Now, in like Google and Facebook and other means, other social media, there may be an option to indicate like who is going to take control of an account after you pass away, but that only is so far as like who's going to control the account and do what's necessary to close it out. It does not indicate who is going to keep all those pictures that you have from like, family reunions past that are stored in an album in Facebook. It's a good idea to just note that and just be very clear about who you want to have those digital assets. So we've talked today about, things that you should consider before drafting a will. And we also covered some of the mistakes that you should avoid. And we talked about 6 in particular. As I promised, I do want to offer you our free will preparation checklist. Like I said, it's free. And you can access it by going to our website at elsawsmithlaw.com. Go to the resources tab. In the drop down, you'll see will preparation checklist. It's free. Download it, use it. We are trying to add as many new resources as we can. And like I said, they're free because we want to help. I understand that the process of, estate planning, can be a bit overwhelming, but it's having checklists, it's having tools that are going to make things not so burdensome before you, meet with that estate planning attorney, which I hope you do, because you want to make sure that you're consulting with a professional who's aware of the laws, changes in the laws. And this is something you don't want to DIY for sure. I want to thank you so much for tuning in to this episode of Women Winning Wednesdays. If you need assistance with estate planning matters in Maryland or the District of Columbia, and you want to just have a strategy session, call us at 410-995-7719. For those free educational videos I spoke about earlier, you can visit and subscribe to our growing YouTube community. It's amazing at Elsa W. Smith Law. Okay, Elsa W. Smith Law. View all the videos that we have. Give us a call if we can help. Join us next week for another live segment of Women Winning Wednesdays. I want to thank you all so much for joining me this week. I'm Elsa W. Smith, your Maryland estate planning attorney. Take care, everybody, and I'll see you next week.